Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Have you ever stopped to think about how just one word, maybe a single definition, can spark this huge multi-million-dollar legal fight, especially in tech, where innovation moves so fast?
Absolutely. It's not just arguing over words. It's really about protecting core intellectual property, the kind of thing that gives a company its edge.
And today, we're diving deep into a really fascinating case that shows exactly that. It's a major clash between a software innovator and a tech giant. And it all comes down to patent claims and what the technology really means. So our mission here is to break down this complex legal judgment. It's from the United States Court of Appeals for the Federal Circuit in MasterMine Software, Inc., the Microsoft Corporation. We're going to walk you through the kind of tricky details of patent law, claim construction, and this really crucial difference between software systems or apparatuses and methods.
Yeah, it's not just about what happened, but why it's so important, especially if you're dealing with software patents.
Exactly. So let's understand who was involved and where this all played out.
Okay, setting the stage. This was case number 2016-2465, and the court was the United States Court of Appeals for the Federal Circuit. That's the go-to court for patent appeals, as you probably know.
Right, specialists.
Precisely. The judgment came down on October 30, 2017. The panel had 3 circuit judges, Newman, O'Malley, and Stoll. Judge Stoll actually wrote the opinion we're digging into.
Got it. And the parties.
On one side, you had the plaintiff appellant, that's MasterMine Software, Inc. They were the ones appealing the earlier decision. Their legal team included Adam Roger Steinert from Frederickson and Byron.
Okay.
And on the other side, the defendant appellee, Microsoft Corporation, the tech giant. They were represented by Erica D. Wilson and Eric Stephen Walters from Walters Wilson LLP.
So MasterMine was really in a tough spot here. They'd already lost at the district court level, right? In Minnesota.
That's right. The district court for the District of Minnesota, Judge Patrick J. Schultz presiding. He ruled against them on how their patent claims should be interpreted, that's claim construction, and also said some claims were invalid because they were indefinite.
Indefinite. We'll definitely need to unpack that term later.
We will. So MasterMine essentially agreed to a judgment saying they didn't infringe and the patents are partly invalid just so they could appeal those key underlying rulings to the Federal Circuit. They lost round 1, basically, and this appeal was their shot at turning things around.
Okay, sounds like a real uphill climb. Before we get to what the appeals court decided, what exactly was this innovation MasterMine was fighting so hard for?
Good question. The whole fight was about 2 related patents MasterMine held. U.S. patent numbers 7,945,850 and 8,429,518. Both patents describe, methods and systems for making it easier to mine and report data from what's called a CRM application.
CRM, Customer Relationship Management.
Exactly. Think sales software, customer service logs, all that stuff companies use to manage customer interactions. These applications integrate, sales teams, business processes, sales channels, customers, all in one place.
Okay.
MasterMine's invention was pretty clever. It was a system that could automatically pull data from that CRM system and generate an electronic worksheet. And this worksheet wasn't just a data dump. It contained a multi-dimensional analysis table. You probably noticed the pivot table.
Ah, pivot tables. I know those. Very useful for slicing and dicing data.
Right. And the whole point was to let users quickly and easily summarize or view large amounts of CRM data. You could rotate the rows and columns, filter the data, drill down into details, basically mine that CRM data for real insights without needing to be a database expert. It aimed to simplify data analysis quite a bit.
Sounds incredibly useful, yeah, especially back then. But this brings us straight to the first big legal fight. What is a pivot table according to MasterMine's patents?
It seems simple, but it became a huge sticking point. The district court, the first court, defined it pretty tightly. They said it's an interactive set of data displayed in rows and columns that can be rotated and filtered. Note the word displayed.
Okay, displayed, so it has to show data.
That was the district court's view. MasterMine, however, pushed back hard. They said, no, that's too narrow. They proposed it should be a computer software object or structure defining an interactive table. Their big argument was that the court's definition wrongly excluded tables that might be generated structurally, but don't actually contain or display data the instant they're created. They felt the patent covered the underlying structure, data or no data at first.
So the potential versus the actual display.
Kind of. And here's where it gets really interesting. The Federal Circuit, the appeals court, looked at all this and actually agreed with the district court. They affirmed that narrower definition.
Really?
Their reasoning relied heavily on what lawyers call intrinsic evidence. Basically, the patent document itself, the claims, the detailed description, the back and forth with the patent office. This is standard practice, following big cases like Phillips v. AWH. You look inside the patent first.
Okay, so what did the patent itself say?
Well, first, the claim language. The court noticed that every time the claims talked about generating a pivot table, the language immediately connected it to containing or presenting data. Claim 1 of the 850 patent, for instance, explicitly says, automatically generating a pivot table, wherein the pivot table contains the CRM data. Similar stuff was in other claims, too, like Claim 12 and Claim 8.
Contains. That word seems pretty important then.
Hugely important. It strongly suggested the claimed invention wasn't just an empty structure, but one defined by holding data.
Okay, what else did they look at?
Next up was the patent specification. There's the detailed written description of the invention. Even the abstract said the report includes a pivot table for displaying the data. And the main text explained the purpose was to summarize or view large amounts of CRM data and let users analyze the captured CRM data. Again, the focus seemed to be on the table actively showing and working with data.
So the patent's own description kept emphasizing the data aspect.
Right. It made it hard for MasterMine to argue it meant an empty table structure when the patent kept talking about viewing and analyzing data within the table. And one more piece. The prosecution history. This is the official record of talks between MasterMine's lawyers and the patent office when they were trying to get the patent approved.
What happened there?
During that process, MasterMine actually argued their invention was different from prior art because their pivot table was created when filled with data. Essentially, they themselves implied the table needed data to be complete. While the court didn't treat this as a formal disclaimer, it definitely added weight to the idea that MasterMine intended the pivot table to be populated from the start.
Wow. So their own arguments came back to bite them, in a way.
It certainly seemed to factor in. The court did look at MasterMine's technical points about code snippets potentially creating empty tables, but found the overall evidence from the claims and specification pointed much more strongly towards a data-filled table upon generation.
Okay, so the bottom line on pivot table was that it has to contain data when it's generated, according to the court. That was a win for Microsoft on that point.
The definite win for Microsoft. It narrowed the scope of MasterMine's patent right there.
But like you said, that wasn't the end of the story. There was this whole other challenge about the claims being indefinite. Let's get into that. What does indefinite mean in patent law?
Right, the second hurdle. Indefiniteness comes from the patent statute itself, 35 U.S.C. Section 112, paragraph 2, in the version that applied here. It basically says patent claims have to particularly point out and distinctly claim the invention. They need to be clear.
Clear enough for who?
Clear enough for someone skilled in the relevant technology, those skilled in the art, to understand the scope of the invention with reasonable certainty. That reasonable certainty standard comes from a key Supreme Court case, Nautilus v. Biosec. If people in the field can't figure out what the patent covers and what it doesn't, the claim fails for indefiniteness.
Okay, makes sense. So what was the specific problem Microsoft had with MasterMine's claims?
The issue, and it's a common one with software patents, was that some claims seem to improperly mix two different types of claims into one. They seem to describe both an apparatus, like a system, the software itself, and a method of using that apparatus.
Why is it a problem?
Because it creates ambiguity. The Federal Circuit talked about this in a case called IPXL Holdings v. Amazon. If a single claim covers both the system and how someone uses it, it's unclear when infringement actually happens. Is it when someone just makes or sells the system? Or does a user have to actually perform the specific method steps described in the claim using that system? That uncertainty is the core of the indefiniteness problem here.
Gotcha. And Microsoft argued that several of MasterMine's claims had this exact problem, and the district court agreed.
Exactly. Microsoft pointed to claims 8 and 10 of the 850 patent and claims 1, 2, and 3 of the 518 patent. They said these claims improperly blended method steps like user actions into system claims. And yes, the district court sided with Microsoft, finding those claims invalid for indefiniteness. Another loss for MasterMine at that stage.
But this is where the Federal Circuit disagreed.
Correct. This is where MasterMine got a win on appeal. The Federal Circuit reversed the district court on the indefiniteness issue. They took a more nuanced view. They emphasized that just using functional language in an apparatus claim doesn't automatically make it indefinite. You're allowed to describe what parts of a system do or what they're capable of. You don't always have to use that very specific means plus function format, which has its own strict rules.
So describing functions is okay sometimes.
Yes, the court drew a careful line. They looked back at those problematic cases like IPXL. In IPXL, the claim literally said, the user uses the input means. That's clearly describing a user action. Same thing in Ringcats, where it talked about callers digitally enter data. Again, user action. And in Rembrandt, a system claim ended with a separate action, transmitting frames.
So those cases involved clear user actions or separate method steps tacked onto a system claim.
Precisely. The Federal Circuit said MasterMine's claims were different. They were more like claims found valid in other cases. For example, HTC v. IPCOM, where functions describe the environment the device operated in, not user actions. Or MEC v. Texas Instruments, where a processor was described as performing an evaluation that's a function of the processor itself. And Ultimate Pointer v. Nintendo, where generating data described the capability of a sensor, not something a user did.
Okay, so the key is whether the language describes the system's capability or an external user's action.
You got it. That seems to be the core distinction the court was making.
So let's look at MasterMine's Claim 8 again. It described a system with a reporting module, and then said the module presents fields, receives a selection from the user, and generates a query. How did the court see presents, receives, generates?
The court found that those verbs describe the capabilities of the reporting module itself. It described what the software module, as part of the claim system, could do. It wasn't describing separate actions the user had to take for infringement to occur, like in IPXL or CATS.
Even though it mentions receives from the user.
Apparently not in a way that made it indefinite. The court emphasized that this functional language was specifically tied to structure, the reporting module. It wasn't a free-floating method step. It described the inherent function of that piece of the system. The module is capable of receiving input and generating output as part of its design.
Ah, I see. So the capability is built into the module structure.
That was the reasoning. Therefore, the court concluded, these claims did tell people skilled in the art what the invention covered with reasonable certainty. Infringement would occur if someone made, used, or sold the system with that reporting module having those capabilities. It didn't depend on a user actually performing those steps at a specific time.
So a big win for MasterMine on that front. Their system claims survived the indefiniteness challenge.
A very significant win, yes. It validated their approach to claiming the software system's functionality.
Okay, so let's recap the final decision. It was a bit of a mixed result for MasterMine, wasn't it?
It really was. The Federal Circuit affirmed the district court's definition of pivot table, the narrower one requiring data. That favored Microsoft.
Okay.
But they reversed the district court's ruling on indefiniteness for those key system claims. That favored MasterMine.
And what happened next?
The case was remanded, sent back to the district court in Minnesota for further proceedings. Basically, the lower court now had to reevaluate the case based on the Federal Circuit's rulings on claim construction and indefiniteness. The fight would continue, but under these new ground rules.
Were there any judges who disagreed? Any dissenting opinions?
No, based on the judgment, it was a unanimous decision by the three-judge panel. Judges Newman, O'Malley, and Stoll all agreed on both the claim construction part and the indefiniteness part.
That makes the ruling pretty solid then. So stepping back, what's the bigger picture here? Why is this case important for people involved in software and patents today?
It has significant legal value, I'd say, on two main fronts. First, regarding claim construction, it just hammers home how vital that intrinsic evidence is. The words you choose in your claims, how you describe the invention in the specification, even what you say to the patent examiner, it all matters immensely. Courts will rely heavily on that evidence.
So patent drafters really need to be careful with their language.
Absolutely. Every word counts. Second, and maybe even more critical for the software world, is the guidance on indefiniteness. This case is a key precedent. It helps clarify how you can write apparatus or system claims using functional language to describe what the system does without accidentally crossing the line into claiming a method within the same claim.
That line between describing capability and describing user action.
Exactly. It reinforces that describing the inherent capabilities of a system component tied to its structure is generally okay. But describing what a user does with the system as part of the system claim itself or adding isolated method steps, that's where you risk indefiniteness. It provides really valuable insight for anyone trying to patent software systems.
So, if we had to boil it down to one single key takeaway for our listeners, what would it be?
I think the most crucial takeaway is this. When patenting software systems, be crystal clear about whether you're defining the system by its built-in capabilities or by how a user interacts with it. Putting user actions directly into an apparatus claim is risky business and can make it invalid. This case really highlights how carefully you need to navigate that distinction.
It's a fine line, but a critical one. We've really walked through a fascinating legal journey here, from defining a seemingly simple term like pivot table to wrestling with the complexities of system versus method claims. It really shows how much legal interpretation impacts innovation, doesn't it?
It absolutely does. And this ruling wasn't the final word of the MasterMine versus Microsoft saga, but it set crucial parameters. It definitely shaped how software patents, especially those describing system functions, are drafted and interpreted now.
It makes you think looking forward. With things like AI and sophisticated data analysis tools becoming more common, how will patent claims evolve? How do you claim something that's both a system and an active, maybe even learning participant?
That's the million-dollar question, isn't it?
Yeah.
How do you distinctly claim technologies that blur those lines even further? It's something patent law will continue to grapple with. Definitely something to ponder.
Indeed. We hope this deep dive gave you some valuable insights into that ongoing evolution. We encourage you to think about these nuances, maybe even look into other key patent cases yourself. Thanks for joining us on this exploration today.